answer questions. I'm going to start with Mr. Eisenberg. And as he knows, and everybody on this committee knows, protecting whistleblowers is very important to me. I want to ask about a 2022 Department of Defense IG report claiming that you retaliated against Eugene Vindman for reporting President Trump's 2019 call with President Zelenskyy. I have serious concerns about the political motivations underlying the whole issue, and I have questions about the report itself, but I want to hear from you directly. How do you respond to the charge that you retaliated against Mr. Vindman?
Thank you, Mr. Chairman, for that question. First, I wholeheartedly deny the allegations. I'm just not that kind of a person. I would never let anything other than the facts of how someone's performing enter into an evaluation. If I had done so, I would not be here seeking this office. Let me note one other thing at the beginning. I was in the White House at the time. All of these events happened within that confines, and so virtually everything is subject to executive privilege. When the Office of the Inspector General called my lawyer to say that they wanted to interview me, my attorney advised me that we would need the permission of both the then current Biden administration and the former Trump administration. That's because they were the holders of the privilege, of that executive privilege. My attorney called them and sought that permission, but we didn't get permission until after the report, which sort of came out of the blue to us. We didn't get that permission until after that report dropped. Consequently, the Office of the Inspector General was wholly without with anybody telling that side of the story. I did not, and none of the other people that had allegations against them in that report were able to sit for an interview. Now, that stuff, that material is in general subject to executive privilege. But I feel like I could give a few examples of why my evaluation of Mr. Vindman changed just based on what's in the IG report, which is now public. As an initial matter, it's clear that I told Mr. Vindman at some point that in order to go to meetings over a certain level or about certain topics, he needed to get permission from either me or my deputy. But then we find out that Mr. Vindman would add himself to meetings, which means he was trying to get into that meeting, even if I had made even if I had made no determination, or actually a determination that he shouldn't be there. Meetings like this aren't like standard meetings within a company trying to figure out how much product to make this year. Those meetings have some of the most sensitive information that the United States government has. And the deliberations in those meetings can often be extraordinarily sensitive in and of itself. So you only send somebody to a meeting if they have something to add to that meeting. Otherwise, you're exposing someone to classified information despite the fact that there's no reason for it. And we're not supposed to do that. We even found out subsequently that Mr. Vindman went to a meeting after I had told him expressly not to go to that meeting. At another time, we found out that Mr. Vindman was seeking reimbursement for his brother's travel expenses to Ukraine. Both my deputy and I told Mr. Vindman that he couldn't do that there was an obvious conflict of interest. Nevertheless, we heard that Mr. Vindman continued to do that. Relatedly, we heard that and this is in the IG report as well, we heard that Mr. Vindman, that a particular witness reported that Mr. Vindman turned red in the face when he met, some resistance to getting money on behalf of his brother. I wouldn't tolerate that in my office if someone goes and tries to intimidate, yells, or anything. It's critically important that especially lawyers in the NSC act like lawyers. That's not everything by any stretch, but it's the stuff I can glean from the public report.
Mr. Shumate, I've got an opening statement. I'm going to just quote Justice Kagan on nationwide injunctions, quote, "It just can't be right that one district judge can stop nationwide policy in its tracks and leave it stopped for years it takes to go through the normal process," end quote. What is your perspective on the use of nationwide injunctions, and is there a role for Congress to play in ending the practice?
Thank you, Mr. Chairman, for that question. I agree with that sentiment. We've seen an unprecedented number of nationwide or universal injunctions just in the first 2 months of the Trump administration. The department's position has been consistent across administrations that single district court judges do not have the power to issue nationwide or universal relief. Our position flows from Article 3 of the Constitution, which limits courts to deciding the case or controversy before them. And courts are supposed to apply doctrines like standing and reviewability and scope of relief to award relief to the party before them and redress that injury, not go beyond the parties. But we've seen district court judges grant relief far beyond the parties to those cases to enjoin the executive branch nationwide or universally. And in terms of whether there's a role for Congress to play, yes, Senator, the Constitution creates one Supreme Court, but vests in Congress the authority to ordain and establish the lower courts. And over time, Congress has certainly created courts, eliminated courts, created jurisdiction, limited jurisdiction, and created special review procedures for review of agency action, whether it's 3-judge courts or direct review in the courts of appeals. So certainly there is a role for Congress to play, Senator.
Senator Durbin.